By now, you already know that the Supreme Court has ruled that race should not be explicitly used when determining which students get accepted to college. But there's a pretty large exception to this new rule. One higher education institution can still use race when determining who gets accepted and who does not. You want to know who it is? First, you have to understand the 6 conservative justices spent more than 100 pages in today's affirmative action ruling arguing that race should not be a determining factor in who gets accepted to college, saying in this day and age, colleges should be considering students based on their experiences as individuals, not using race. And by using race as a factor, they say it violates the Equal Protections Clause of the 14th Amendment. But buried in a footnote on page 22 of the majority opinion, Chief Justice John Roberts says military academies can still use race when determining who gets in and who does not. How does that make sense? Well, the footnote says race-based acceptance in military academies can be allowed because the United States military has a, quote, potentially distinct interest in creating diversity among the military leadership. The liberal justices immediately called out the hypocrisy of this military carve-out by the conservatives. In her dissent, Justice Sotomayor basically says, which is it? Does affirmative action violate the 14th Amendment or not? And why is it okay for the military academy to use race as a factor, but not, for example, a religious university? She says this carve-out only convolutes the majority's opinion and further proves that the 14th Amendment does not categorically prohibit the use of race in college admissions.